Thank you very much, Madam Moderator. Good afternoon, Excellencies, panelists, distinguished ladies and gentlemen. It is with great honor that I stand here today as the Solicitor General of the Gambia to express the Gambia's strong support for the establishment of a treaty on crimes against humanity. This initiative is not just timely, it is absolutely essential. The absence of a dedicated treaty perpetuates a significant gap in the international legal framework, allowing for impunity and depriving vulnerable populations of the protections they desperately need. Africa has a vital role in shaping the future of the negotiations for a treaty on crimes against humanity. In the latest session of the United Nations Sixth Committee in April 2024, the Africa Group issued a collective statement demonstrating the continent's readiness to engage constructively in establishing a framework for the prevention and punishment of crimes against humanity. However, most African states have not yet clarified their positions on advancing the process to formal treaty negotiations regarding the draft articles, a decision expected from the Sixth Committee by the end of November 2024. As we know, crimes against humanity represent some of the most egregious violations of human rights. The Gambia firmly believes that moving the draft articles on the prevention and punishment of crimes against humanity into formal treaty negotiations is a critical step towards enhancing accountability and safeguarding human rights globally. Moreover, it is imperative that other African governments join us in co-sponsoring the resolution to advance this initiative. Currently, only a handful of African states, notably Liberia, Sierra Leone, South Africa, Ghana, Senegal, Mauritius, and Botswana, have committed to this cause alongside the Gambia. A united front from the African continent is therefore crucial. It will not only amplify our collective voice, but will also significantly influence the outcome of the Sixth Committee's decision-making process, which traditionally relies on consensus. Excellencies, ladies and gentlemen, the Gambia supports the establishment of a treaty on crimes against humanity to address impunity and enhance accountability for serious offenses, providing greater protection for vulnerable populations. On behalf of the government and people of the Gambia, I call on all other African countries to join in co-sponsoring the resolution to move the draft articles on crimes against humanity to negotiations to strengthen the continent's collective voice in international law discussions and promote accountability for serious human rights violations. A greater number of co-sponsors would amplify the message sent to the international community, increasing the likelihood of a successful negotiations and a favorable outcome. Ultimately, supporting the resolution aligns with Africa's shared commitment to justice, human rights, and addressing both past and ongoing injustices. I therefore take this opportunity to urge all stakeholders to recognize the value of this initiative and to work together to ensure that the voices of those affected by crimes against humanity are heard and acted upon. Together, Excellencies, distinguished ladies and gentlemen, we have the power to foster a stronger commitment among African nations to uphold justice and protect human rights for all. I thank you all for your kind attention and wish you a successful deliberation. Thank you.
Merci, Monsieur le Procureur général. Nous allons passer le témoin à Madame Simiti Lavali, commissaire près la Commission des droits de l'homme de la Sierra Leone. Madame, vous avez la parole.
Thank you, Madam Moderator. Madam Moderator, Honorable Solicitor General of the Republic of the Gambia, other members of the High Table, fellow NHRIs present, civil society colleagues, members of the Fourth Estate, ladies and gentlemen, all protocols duly observed. It is a pleasure for me to be here at the 81st session of the African Commission on Human and People's Rights and to make a statement at this very important side event. Thank you to Global Justice Center and other organizers for the kind invitation. The Human Rights Commission of Sierra Leone is a grade A national human rights institution. It was established as an accountability mechanism by an act of parliament in 2004, following the recommendations of the Truth and Reconciliation Commission, in bracket TRC, that came about as a result of the 11-year civil war in Sierra Leone from 1991 to 2002. Alongside the TRC, the government of Sierra Leone also requested assistance from the United Nations to set up the Special Court for Sierra Leone, in bracket SCSL, a hybrid international tribunal created by a treaty between the United Nations and the government of Sierra Leone in 2002, and authorized by UN Security Council Resolution 1315. The Special Court for Sierra Leone's mandate was to try those with greatest responsibility for the war, with war crimes, crimes against humanity, and other related offenses. At that time, and up till now, crimes against humanity did not have a treaty outlining the specific acts constituting it, nor was there an obligation on states to take measures to create liability within national laws and accordingly investigate and prosecute offenders. With the adoption of the draft Articles on Prevention and Punishment of Crimes Against Humanity 2019 by the International Law Commission, the international community has taken a big step towards closing that gap. I am pleased to inform that the government of Sierra Leone has publicly expressed its support for the proposed Crimes Against Humanity Treaty. Our government did so first in April at a side event during the resumed session of the 6th Committee of the UN General Assembly with the theme Incorporating Slavery and Slave Trade Crimes in the Rome Statutes and the proposed Crimes Against Humanity Treaty. A week ago, a further public declaration was made at the 79th session of the 6th Committee. Sierra Leone has gone further to express its willingness to host the International Law Commission recommended diplomatic conference for the adoption of the Crimes Against Humanity Convention. This clearly demonstrates Sierra Leone's principled commitment to ensuring accountability for international crimes. To my fellow national human rights institutions colleagues present here at this gathering and watching us online, we have a role to play in encouraging our states to co-sponsor this important draft treaty. We have an obligation to draw the attention of our governments to propose treaties that would enhance the enjoyment of human rights nationally or internationally. As we just heard even from the Solicitor General, there are still a number of states that are yet to register their support. I've noticed within the sessions, I don't know if they're present here, we have colleagues from Namibia, Zimbabwe, Kenya, Guinea-Bissau, Burundi, Tanzania. For those of you who are present here, taking this opportunity to call out to you to reach out to your states. From now to November 2024, I'm urging you to reach out to your respective governments to co-sponsor the resolution for treaty negotiation. You could do this through writing a letter to your head of state, drawing his or her attention to this treaty, or by deepening engagement with your Ministry of Foreign Affairs or your Ministry of Justice. I commend our sister NHRI from Liberia, who recently engaged a head of state to positive effects. In countries that have already agreed to co-sponsor, there's still work to be done. There are several things that you can do, such as show public backing for the political and legal decisions taken by states on making this a reality, to monitor the process and ensure that any such treaty serves the purposes of accountability for such crimes and one that makes the interests of victims a priority. You could also do it through public awareness, raising and education, promoting public understanding and support. Could also lead advocacy to mobilize additional state support. And finally, you can also engage with civil society or groups to enhance advocacy efforts. This is an opportunity for us to take a principled position together as regional NHRIs to take advocacy to our respective states and ensure political support by our governments. In closing, I will re-echo the call made by our Sierra Leone's representative in New York for a clear, comprehensive, and inclusive legal framework aimed at ending impunity for crimes against humanity and ensuring accountability. We should no longer have to rely on customary international law and jurisprudence from international criminal courts and tribunals, but move to have a comprehensive standalone convention that would strengthen the protection and punishment of heinous crimes at the national level. I'm proud that Sierra Leone is using its time at the UN Security Council to shine a light on human rights issues and make accountability for serious crimes a fundamental issue for global peace and security. Thank you for your kind attention and wish you fruitful deliberations. Thank you.
Merci, Madame Lavallée. Vous avez sans doute compris, nous profitons de cette opportunité, la tribune qui nous est offerte par la Commission, pour nous interpeller entre nous, la société civile, parce que nous avons un rôle à jouer dans les États pour susciter l'adhésion à ce texte. Et donc, Monsieur Japhet Biegon, coordinateur de plaidoyer pour l'Afrique à Amnesty International, va nous présenter le draft et les éléments clés de ce projet. Monsieur Biegon, vous avez la parole.
Thank you, Madam Moderator, and for this opportunity. My role is pretty simple, to really provide a very broad top-line overview of the draft convention or draft articles on the prevention and punishment of the crimes against humanity. But first, just a brief history. The topic on the draft convention was first introduced to the International Law Commission, which, as you may know, is a subsidiary organ of the United Nations, in 2014. So essentially, the draft convention has been in the making so far in 10 years, and it's now at the cusp of going into the next phase of negotiations. Having been introduced the idea or the topic in 2014, the International Law Commission in 2019, 5 years later, published the draft articles on the prevention and punishment of crimes against humanity. And it is this draft that we've been speaking about, and that is meant to go into negotiations, subject, of course, to subsequent processes, including the resolution that Mexico and the Gambia has circulated. In terms of the structure, I do not think the time allowed to me for me will be sufficient to go into detail on the draft convention, but my colleagues here that will be speaking will also go into certain aspects of it into more detail. But the draft convention, in terms of structure, is composed of 15 provisions and an annex. And like any other proposed treaty, it has a preamble that has 10 paragraphs. But perhaps to mention in this preamble, one of the important aspects is in paragraph 4, that affirms that the prohibition against crimes against humanity is a jus cogens norm from which no derogation is permissible. Essentially, states are under an obligation to ensure that they cannot derogate from the obligation that prohibits crimes against humanity. Article 1 provides for the scope of application of the convention. Article 2 then defines crimes against humanity, and it replicates the definition under the Rome Statute under Article 7, save for the fact that it does not include a definition of gender, leaving it to the discretion of states. And I think one of my colleagues might go into that in deeper detail. Then Articles 3 to 4 deals with general obligations and the obligation to prevent crimes against humanity. And I'll come to this in a short while. Article 5 deals with non-refoulement, the principle of non-refoulement that, as you may know, is also a principle applicable under international refugee law, but also in this context under crimes against humanity. Then Articles 6 to 10 deals with criminalization of the offense of the crime against humanity. It deals with the assertion of national jurisdiction and obligations to prosecute and extradite, to which, again, I'll come on to it. Articles 11 to 12 deals an important issue about a justice system. That's the fair treatment and fair trial rights of the alleged offender, and also goes beyond the fair trial of the alleged offender into the rights of the protection of victims, witnesses, and other relevant persons that may be involved in a case concerning crimes against humanity. Articles 13 to 14 deals with mutual legal assistance and extradition measures, what states need to do in terms of cooperation, but also in terms of extraditing an alleged perpetrator of a crime against humanity. And then finally, Article 15 deals with the settlement of disputes, stating that disputes of the interpretation and application of the future convention will, if not settled by negotiation or arbitration, it should be submitted to the International Court of Justice unless the states have chosen the option of arbitration. So in broad terms, there are three main things that I can say that the convention seeks to achieve. And there are many objectives of the convention, but I just want to highlight three. One is that it really sets new pathways to ensure justice, truth, and reparation for victims of crimes against humanity. Two, it provides a comprehensive framework for enabling all countries to incorporate crimes against humanity into their national legal systems, and therefore to be able to carry domestic investigations and prosecutions against people or perpetrators of crimes against humanity. And then finally, it seeks to reduce safe havens for perpetrators, that you cannot therefore run from one country to another, because it provides for you as a perpetrator a safe haven from prosecution or investigation. Allow me in the last few minutes now to focus on four specific things that I think should be highlighted. One is the obligation to prevent. Article 3 and 4, as I already mentioned, introduces an obligation of states not just to prosecute and investigate crimes against humanity, but to also prevent crimes against humanity. This obligation is formulated pretty much the same way the Genocide Convention has formulated the obligation to prevent. And it requires states to employ at all means at its disposal to prevent the commissions of crimes against humanity. This means it must deploy its best efforts, and this therefore incorporates a due diligence standard. When the state has the capacity to influence effectively the action or persons likely to commit or those who have already committed those acts, then in that scenario, the state has a responsibility to actually prevent commissions of crimes against humanity. The second broad issue that I wanted to highlight, perhaps in a slightly deeper way, is the obligation to prosecute or extradite that is provided under Article 10. And this also comes with a wide array of grounds of jurisdiction for the for assertion of a jurisdiction. Article 7 provides that the state must establish domestic jurisdiction over crimes against humanity. And it does this in a number of ways. One is territorial jurisdiction, where the perpetrator or the victim is a national of that state, where the perpetrator is within the territory of a particular state. It also provides for personality jurisdiction, personal jurisdiction, either active or passive. That is where the perpetrator or the victim is a national of the state concerns. But more importantly, one other area of jurisdiction that the Convention against the Convention on Crimes Against Humanity provides is universal jurisdiction. It essentially ensures that criminal investigations and prosecutions of crimes against humanity is a duty of all states, regardless of where this crime has been committed. Therefore, the present obligation that is enshrined in this treaty, as contained in Article 10, would greatly enhance the prospects of persons suspected of crimes against humanity being tried either in the state where those persons can be apprehended, or in a second state, in case of or in an international tribunal with respective jurisdiction. So the provision of universal jurisdiction is an important aspect of the convention. Then there is the strengthening of international standards on justice for sexual and gender-based crimes, which I already mentioned that it deletes the repressive definition of gender as contained in the Rome Statute and allows now for a more progressive, a more widened definition of gender in terms of prosecution of crimes against humanity. Then finally, it provides for the possibility of dispute settlement before the International Court of Justice under Article 15. The interpretation and application of the future convention, if it will not be settled by negotiation or by arbitration, then the states will have the possibility of submitting questions of interpretation of the convention to the International Court of Justice. And we have seen this working in the context of the Genocide Convention, where countries have submitted cases to the International Court of Justice, including most recently by Gambia, by countries like South Africa. Therefore, this provides an opportunity to hold states accountable in case they are not abiding by their obligations under the future convention, as it has been done under the Genocide Convention. So this really provides a very broad top-line overview of the convention, and I will seek now to stop there. Thank you so much.
Merci beaucoup, M. Biegon. J'aimerais proposer de prendre les questions à la fin ou après chaque intervention. Qu'est-ce que vous en pensez? Après ça, d'accord. Merci. Je pense que vous avez suivi l'intérêt qui vous a été présenté, l'intérêt d'adopter ce texte, de pousser nos États à adopter ce texte pour mettre enfin en application l'adage selon lequel mieux vaut prévenir que guérir, parce que c'est toujours pas évident après de guérir lorsque les mots sont déjà très prononcés. Mais en amont, on peut poser des actes allant dans le sens de dissuader les auteurs de ces crimes, en incorporant dans notre corpus national les dispositions de ce traité et en faisant en sorte que cette fois-ci, ces crimes soient jugés sur nos territoires. Nous allons passer à M. Sadick Niass, directeur des relations internationales Afrikajom Center, qui va présenter l'intérêt et l'importance pour les activistes de pousser nos États à soutenir ce texte. Monsieur Sadick, vous avez la parole.
Merci, Présidente. Monsieur Hussein Thomasi, procureur général de la Gambie, Madame Simiti Lawali, commissaire à la Commission nationale des droits de l'homme de Sierra Leone, Madame Alide Bouangui, vice-présidente de la FIDH, Mesdames, Messieurs les panélistes, Mesdames, Messieurs les participantes et les participants. Il est essentiel aujourd'hui de disposer d'un tel traité dans la mesure où, à la différence des autres crimes similaires tels que les crimes de génocide, les crimes de guerre, il n'existe aucun traité obligeant les États aujourd'hui à prévenir et à réprimer les crimes contre l'humanité. Une convention sur ces crimes permettrait de combler cette lacune alors. Elle définirait expressément, comme l'a si bien dit notre ami tantôt, les obligations des États en matière de prévention, de répression de ces crimes. Il y a également le fait que cette convention, ce traité serait complémentaire. Je pense qu'Allan va y revenir avec la CPI, dont un grand nombre d'États africains sont déjà membres, mais contrairement à un traité, les statuts de la CPI ne poursuivent que les individus, donc, et non pas les États. Un traité sur les crimes contre l'humanité peut également servir comme cadre de coopération entre les États dans le cadre de la poursuite de ces crimes. Maintenant, de la nécessité d'avoir ce traité en Afrique, il est crucial de noter que le moment est critique aujourd'hui pour les États africains qui ont un rôle particulièrement important. Je pense que les gens qui ont parlé en ont déjà parlé, à jouer, car c'est seulement, en tout cas c'est sur le continent africain que l'on observe à la commission de crimes tels que des crimes de masse, des viols, des atrocités qui méritent d'être punis, en tout cas de la responsabilité de ces États. Je ne pourrais pas poursuivre sans citer ce qui se passe aujourd'hui au Soudan. Il y a d'autres États comme au Nigeria, en République RDC, au Burkina Faso, au Mali et ailleurs, effectivement, où les plus grandes victimes de ces atrocités, ce sont les femmes et les enfants. D'où la nécessité d'avoir un tel traité pour le cadre de la protection des victimes, que sont les femmes, surtout les femmes et les enfants, mais également d'autres groupes vulnérables, mais également dans la poursuite des auteurs. D'où l'intérêt d'avoir effectivement un traité allant dans ce sens pour protéger ces victimes et poursuivre les auteurs. Il est crucial aussi de faire en sorte que le futur traité sur les crimes contre l'humanité, et je pense que celui qui m'a précédé en a parlé, reflète effectivement la dimension genre et soit centré sur les survivantes et les survivants. Le projet d'article qui s'inspire largement des statuts de Rome permet de faire des progrès importants dans la compréhension des crimes sexuels et des crimes liés au genre, ainsi que les traumatismes subis par les survivantes des crimes, de tels crimes. Un nouveau traité international donc devrait prendre en compte ces avancées. Que peut-on faire maintenant en tant que société civile, organisation de la société civile? À l'instar de ce que nous avons déjà fait pour soutenir la CPI, je pense qu'Allan Ngari est là, on a eu à s'organiser dans le cadre d'une coalition pour la CPI, à s'organiser dans le cadre d'une coalition. Le travail que la rapporteure spéciale sur les réfugiés avait entamé pour qu'on arrive à adopter effectivement un protocole additionnel à la Charte africaine sur le droit à la nationalité. Pour dire que ce n'est pas une chose simple et qu'il faut effectivement, dans le cadre de ce nouveau traité également, essayer de faire ce encourager les États déjà qui ont fait ce sponsoring de ce traité. Je pense que le procureur en a parlé pour certains, mais il ne suffit pas, on pourra les citer encore pour émuler d'autres États, le Sénégal, Libéria, Ghana, Maurice, Malawi, Botswana, Lesotho et Zimbabwe ont déjà fait, et nous invitons et nous sommes confiants que la Gambie aussi va s'adjoindre, considérant le chantier que la Gambie est en train d'ouvrir dans le cadre de cette justice pénale internationale en voulant remettre en place un tribunal spécial pour juger les grandes atrocités qui ont eu lieu ici durant ce régime passé. Donc, à l'instant, ces États, nous invitons les autres États à le faire. Et enfin, approcher aussi la Commission, les membres de la Commission africaine, et aussi les organisations sous-régionales comme la CEDEAO, il y a d'autres organisations sous-régionales. Et se servir de cette bonne pratique qui consiste à préparer déjà l'après-adoption de ce traité en termes d'adhésion, de ratification de masse dans ce cadre. On l'a fait quand il s'est agi vraiment du droit à la nationalité. On avait préparé les organisations sous-régionales, surtout la CEDEAO, pour que les 15 États de la CEDEAO puissent en même temps, en tout cas, ratifier d'emblée ce protocole. Donc, il faut déjà commencer à travailler dans ce sens pour que demain, si on adopte ce protocole, ce traité, que la ratification soit beaucoup plus simplifiée. Et que ces organisations sous-régionales, que ce soit la Commission africaine et les autres organisations sous-régionales, puissent inscrire dans leur agenda, effectivement, ce processus et en cas d'ouverture par les Nations Unies de négociations formelles pour l'adoption d'un traité sur la base de ces 15 articles dont parlait tantôt mon ami, que effectivement le travail puisse être beaucoup plus simplifié. En tout cas, on prendrait les devants dans ce sens. C'est ça que je voulais partager avec vous et je vous remercie.
Merci, Monsieur Sadick Niass. Nous allons passer à la phase des questions.
Je pense que moi, je ne peux pas, et aussi Allan, et après les questions.
Donc, à la fin de toutes les interventions.
Je pense.
D'accord, OK. Nous allons donner la parole à Madame Elise Keppler, directrice exécutive de Global Justice Center. Elle va nous présenter le processus pour les négociations au niveau des Nations Unies, comment faire avancer ce texte. Merci, Madame.
Merci, Alide. Thank you, Alide, so much. It's a real honor to be here today and to be seated, especially with the Solicitor General and the Sierra Leone Human Rights Commission Commissioner. Gambia and Sierra Leone have been champions of this treaty initiative and have really been leading the way with the effort to close the gap in international law and expand the toolbox to have prevention and punishment of crimes against humanity. So we are very grateful for your leadership and your participation. Global Justice Center, for those who may not know, is a human rights organization that is focused on using international law to advance gender equality. So we come into the effort to have a first convention on crimes against humanity from the perspective of it being an essential instrument to see government obligations clarified to prevent and punish these crimes, but also to ensure greater recognition of gendered harms under international law. And so we are part not only of the effort to have this treaty created overall, but to see improvements or recognition of improvements in international law over time for gendered harms. So that includes having not having a definition of gender in the draft text so as to encompass more greater recognition of variation in gender and progressive law in that regard, and also for incorporation and codification ultimately of several crimes which we believe are necessary to encompass gendered harms. Those include the crimes of forced marriage, the crime of gender apartheid, crime of reproductive violence, and of course the slave trade, which Sierra Leone has been leading on advancing for the treaty. But the reality is, having made proposals in relation to these codifications, if the process for a treaty does not advance to negotiations, there will be no opportunity for this codification and incorporation in such a treaty. So at this moment in time, we want to focus attention on moving to formal negotiations for a treaty. Japhet gave us an overview of the provisions and also recognition that this was a draft text developed by the International Law Commission. And the UN General Assembly approved a 2-year, the Sixth Committee of the General Assembly approved a 2-year time span during which governments could discuss aspects of the draft text and then ultimately take a decision, which will happen by the end of the session in November, toward the end of November, on whether to advance to formal treaty negotiations. Now, one of the reasons that Global Justice Center thought it was so important to organize an event at the African Commission is that we believe Africa and the states within the African region have the opportunity to make a determinative impact on whether this process goes to negotiations. And at present, African states have been some of the smallest number to weigh in on whether to support the resolution bringing the process to negotiations. So it's really a moment to take a look at which are the African states that have signed up to co-sponsor the resolution to bring this to negotiations, and where is the energy needed before November to increase co-sponsorship. Sadick and the others, the Solicitor General, have talked about some of the states that are currently co-sponsoring. I want to highlight some of the states that have yet to take a position in Africa, but from past experience, we believe have the potential, are well situated to support this process, either because they are members of the ICC or because they have already expressed verbally support for the treaty but have not taken a position of co-sponsorship yet, or have otherwise expressed support for accountability processes. That includes Ivory Coast, Central African Republic, Benin, Nigeria, Namibia, Uganda, and then several others who have been less involved or who may have complicating situations, but yet still have, we believe, the possibility to sign on. Chad, Gabon, Guinea, Mali, Niger, Burkina Faso. So I would really especially ask the people in the room who are either with those governments, with those human rights commissions, and or in the NGO community to reflect on their government's position and think about what can be done to encourage their governments to co-sponsor the resolution. Now, why is co-sponsorship important? It is clear at this point that the majority of states around the world support a convention, but at the same time, there is a strong tradition in the UN Sixth Committee in favor of consensus practice. And in order to demonstrate consensus for moving to negotiations, overwhelming, clear, on-the-record support will be extremely helpful to a positive outcome. So the concrete action that states can take to show that support is by co-sponsoring the resolution. And we have seen different ways in which communities can encourage their governments to support. For example, Malawi took a position in support, and there was interaction with both representatives in capital and representatives based in New York from the Malawi mission. In Liberia, we saw intervention from the Human Rights Commission to the Ministries of Foreign Affairs and Justice Ministries asking for support, and also from NGOs writing to those ministries and asking for support. And we saw that Liberia took the excellent decision to co-sponsor after some of that engagement happened. So we have a dedicated microsite on the Crimes Against Humanity Treaty, and I'm happy to share that with anyone after. That microsite provides information and background and text should you or any of your colleagues wish to engage your governments on this issue and the importance of African governments stepping up in support. Other possible ways to engage are with public communications, whether or not it's press releases, opinion pieces, but to make clear that this is an issue that civil society and human rights commissions care about, to expand the toolbox for prevention and punishment of crimes against humanity. Now, we know crimes against humanity are widespread, and we do need to recognize that it's not as if a convention will immediately solve that overnight, but it becomes an important instrument to press for states to uphold obligations to prevent and punish these crimes. So it is our hope that in the coming weeks, we will see more co-sponsors. It was up to 87 as of this week when there was a first debate at the UN. And now what we will have are informal discussions happening among governments from all over the world on the draft text for this resolution to move to treaty negotiations. And the more that governments weigh in and support, the stronger position this will be to as we come to a decision in November. My strongest hope is that next year we may have the chance to come back to the African Commission and brief on the actual possibility of negotiations and the ins and outs and how Africa can play its role to see a strongest possible text, because formal negotiations for a treaty will be taking place. Thank you.
Merci, Elise. Enfin, quel est l'intérêt pour nos États de soutenir ce texte? Et cela nous sera présenté par M. Allan Ngari, directeur de plaidoyer pour l'Afrique, Human Rights Watch.
There we go. Thank you very much, Madam Alide, for giving me the floor. And let me start by thanking the governments of the Gambia and Sierra Leone, both represented here by the Solicitor General, as well as the Commissioner for the National Human Rights Institution in Sierra Leone. And just to say that these two countries have really been champions on international justice on the continent. And so it's no wonder and no surprise to see that they're really formidable in their call for other African countries to address this specific issue of sponsoring the resolution at the 6th committee that will lead us then to the negotiations that will happen in 2026. So I would also like to thank our previous speakers who've really elaborated what the ILC draft articles are about, and various other positions that civil society as well as states can take. And just to say, the exhortation that came from Commissioner Simiti Lavali around NGOs writing specifically to governments, writing specifically to the ministers of foreign affairs, is really the key call right now for civil society as we are sitting here, and especially in the countries that we have identified, and my colleagues have spoken to this specific issue of which countries we need to target. So my task was to talk about the value of the treaty for African states, and my work is really easy because the previous speakers have touched on a number of these points. So mine is really just to consolidate and make it very clear to us what the value really is for states. But beyond states, I want us to focus on victims of these serious crimes against humanity in Africa. And the point of departure is that there's not a single region in this continent that has not been affected by conflict and currently still under serious conflict. And because the crimes that are taking place there are tantamount to crimes against humanity, it's really important for us to reflect as a continent on this specific issue. Elise spoke to the significant role that African states need to play to move us to this point at the beginning of November, when we'll have the consensus resolution by hoping that we get to that point. And that's because of the vast number of countries, obviously, that form the bloc. Now I'll talk about some of these countries and what the next step should be. But I wanted us just to reflect on the cyclical nature of conflict and say that in as much as your country might not now be experiencing conflict, it has at some point in the past experienced conflict, or has at some point experienced an authoritarian regime, or has experienced serious gross human rights violations. But because of the cyclical nature of conflict, it's very likely that in the future that, it's not a good thing to talk about, but that's the reality of the world that we are living in. We are very, we don't like each other as human beings, which is not good. And so it's good for us to preemptively ensure that we are able to close the gaps of impunity for these crimes. And this treaty represents one of the hopes for us as Africans to ensure that this serious crime does not go unpunished. So I wanted to speak about the Sahel, for example, and specifically look at Burkina Faso, where we have seen, and Human Rights Watch has documented as well as other organizations, I know FIDH and Amnesty have done this as well, is just documenting the serious extrajudicial killings that are going on in that country in the name of counterterrorism operations. Now, those crimes are tantamount to crimes against humanity. They are widespread, they are systematic, and they're in pursuit of an organizational or state policy. And this is some of the definitions that Japhet was speaking to us about as to what the ILC draft articles provide. And I really encourage that you read it, so that then you would identify that some of the things that you yourself are as organizations working to prevent are really clustered to crimes against humanity. Sudan has also been spoken about by colleagues on the panel, and Sudan remains one of the countries that we are most concerned about with now the conflict, where the extent of sexual violations against women and girls in Omdurman, in Bahri, in Khartoum, in various parts of Darfur, and other parts really in the country. And we've documented very serious sexual violence against women and girls that are really crimes against humanity. And some of them are also targeted at ethnic Masalit people. And you know, that's a different category of an international crime. We stopped at calling it ethnic cleansing, but you know, there has been a lot of conversations around the use of the word genocide and whether we should be specifically talking about genocide in Sudan. Certainly many years ago, in about 10, 20 years ago in Sudan, which is the subject of investigations at the International Criminal Court, there was a very clear sign that the unholy trinity of international crimes against humanity, genocide, and war crimes are taking place. Southern Africa has always been seen as a little bit of a bastion of peace, but what we have been seeing recently with the elections in different parts of Southern Africa and the tendencies of governments to be repressive, not just to opposition political parties, but also to civilians and human rights defenders in a whole. And again, we have to remember the definition of crimes against humanity, that widespread and systematic nature of attack on civilian population and with on that organizational policy component. And so it might be easy for us to actually make the connections and say that this is what this repressive states prior to elections or just after elections are meting out. It's no surprise that when we talk about apartheid, in Southern African countries, Namibia and South Africa, we see why these two countries are really in support of this process that would lead to negotiations for a crimes against humanity treaty. But let me go to the Gambia again and say that while the Gambia is a proportionate small in size, it is a mighty, mighty country. What the Gambia did for justice, not just for Gambians, but it represented such an important a point in our lives and really worth the recognition when they brought the matter before the International Court of Justice related to the Rohingya people who were persecuted, and really it was a genocide against them by the government of Myanmar. And they did that on behalf of the Organization of Islamic States. But the idea that you have this small country in size, but mighty in every sense in terms of international accountability for these crimes, dealing with with people from a different part of the world and saying that this cannot happen under their watch, I think is worth celebrating. And we saw towards the end of last year that South Africa took a similar stand in the conflict in Palestine. And the basis of these two actions was on state responsibility for Myanmar and for Israel based on the Convention on the Prevention and Punishment of the Crime of Genocide. And that's how that state responsibility component was, we were able to have jurisprudence and very clear directives from the International Court of Justice on this. Presently, we do not have that for the crimes against for crimes against humanity. There's very little chance to get state responsibility at this point. And so, what this draft treaty process, what the treaty will do, and Japhet spoke to the last article of the draft articles that speak about the dispute resolution section, is that the International Court of Justice will be able then to be seized by other states in the same way that the Gambia and in the same way that South Africa did for Myanmar and Israel, respectively. That a similar thing could happen, that a state would then bring a matter before the ICJ and say that in this country, and let's say it's an African country, this is happening, and we are standing on the principles of international law, that there is a responsibility for this country to prevent and punish the crimes against humanity. So that's a really great value add, beyond the criminal component of it, beyond the codification of it to the International Criminal Court. We now have another process that is likely then for us to really focus on state responsibility. I also want to pause as I come to an end to talk about the countries in Africa really that we need to work on going forward. And we literally have a few days between now and the beginning of November when this resolution at the 6th committee should be adopted, and hopefully by consensus. So our colleague, Commissioner Simiti Lavali, spoke to the Sierra Leonean statement that was said or that was delivered last week on behalf of 74 countries, not all of them African, but others globally. But then we also saw a few African countries make some positive statements, including some of the countries that Elise just said right now or read to us right now, that we might need to work on a little bit more. And that is Burkina Faso. It is Namibia, it is Niger, it is Mozambique, Republic of Congo, Zambia. Very encouraging statements that would lead to us thinking they are going to vote for, or they are going to join in solidarity with that resolution. But the Lusophone African states have also been very strong. I think it was Mozambique that spoke on behalf of itself, Angola, Guinea-Bissau, Sao Tome, Principe, and Cabo Verde. So it's very clear that the African countries are on their way, but they are a critical body. And if you are representing any civil society organization on the continent and you want to ensure that your country does vote for this resolution or goes on by consensus, adopts this resolution, this is the time to actually write. And we do have templates of how you would be able to do that. You can approach any one of us here on the panel and we will give you the tools for this. So the advocacy tools are ready for that. So just to conclude and say that the value add really for us is the opportunity, and I really liked the word that was given by Japhet, which is the pathways for state responsibility. I think that's a really important one. And of course, limiting the spaces for these actors, perpetrators of these crimes, limiting their opportunity for them to get away with this by the obligation to prosecute or to extradite. We also want to ensure that there's a marked reminder for states that they need to protect civilians, and failure for them to do that will then lead to them being called out in the international community. So there are some challenges around definitions, and you had a little bit of that as the panelists were speaking on gender. Some people are talking about gender apartheid, wondering whether that's the right term to use, or gender persecution. We'll have an opportunity, or states will have an opportunity to deliberate on all these things after this crucial point. And that will be for a 2-year period between 2026 and 2028. And how wonderful it would be if Sierra Leone's great offer is actually accepted, and that these negotiations happen on the African continent. I'll leave it there. Thank you very much.
Merci Allan, notre dernier intervenant. Avant d'ouvrir la phase des questions, je vous annonçais à l'entame de notre activité la présence dans la salle de Madame Maya Fadel, ancienne vice-présidente de la CADHP, ancienne présidente du groupe de travail de la CADHP sur la peine de mort les exécutions extrajudiciaires et les disparitions forcées, ancienne rapporteure spéciale sur les situations des réfugiés, demandeurs d'asile, personnes déplacées et des migrants. Il s'avère qu'elle a appelé à d'autres activités et nous souhaitons tout de même nous donner la parole pour des éventuelles observations. Merci, madame.
Merci beaucoup. Je vais prendre la parole à partir de mon siège. Effectivement, dans un quart d'heure, je vais devoir vous quitter. Alors, je suis tout à fait ravie de participer à cette rencontre. Comme vous l'avez dit, je ne suis plus commissaire à la Commission africaine des droits de l'homme et des peuples, mais je continue encore à lutter pour la promotion et la protection des droits de l'homme. Alors, l'activité qui nous réunit aujourd'hui est importante parce qu'elle nous permet d'abord de mettre en évidence le rôle essentiel des États africains par rapport au projet de convention sur la prévention et la répression du crime contre l'humanité. Vous l'avez bien dit, c'est une convention qui va combler un vide par rapport à ce qui existe déjà, mais du point de vue de la position des États africains, il faut être très prudent. Je dis très prudent parce qu'il n'y a pas encore de position consensuelle par rapport à cette convention et à l'ouverture de négociations prochaines. Si jamais l'Assemblée générale doit adopter la résolution demandant à ce que les négociations formalisées puissent commencer. Alors c'est vrai qu'on a entendu, il y a des groupes d'États qui sont favorables à ce projet de convention. Il y a une partie des États africains qui hésitent encore, mais ce dont on est sûr, c'est que la question de l'opportunité, de la faisabilité ne se pose plus. Il est opportun d'avoir cette convention et c'est également faisable. Maintenant, il faut également prendre en considération les spécificités de certains États africains. Je pense que vous avez évoqué un certain nombre de points qui sont les points qui fâchent un petit peu au niveau des pays africains. Alors, la définition en elle-même, la définition, tous les États africains ne sont pas d'accord pour cet élargissement. Il y a un point qui n'a pas été relevé et qui fait partie également des points qui fâchent, c'est la référence à la compétence universelle qui a été élargie. Et c'est sur ce point que beaucoup d'États africains hésitent à franchir le pas pour aller vers des négociations formalisées. C'est de revisiter l'esprit de la compétence universelle à travers cette convention. Alors, il y a également le fait que beaucoup d'États africains ont dit qu'il y a une relation avec le statut de Rome, bien sûr, mais ça reste quand même insuffisant. Et on a également relevé le fait que cette convention, et vous l'avez dit en ce qui concerne la clause de règlement des litiges, il faut bien faire la différence que le statut de Rome, c'est la poursuite des individus. Adoption de cette convention, ce sera la poursuite des États. C'est la responsabilité des États, État contre État. Et l'enjeu est beaucoup plus difficile et il est très sensible. De notre côté, beaucoup d'États, pendant ces pré-négociations, ont évoqué le fait que cette convention risque encore une fois d'être une convention qui s'appliquera, je dirais presque exclusivement pour les États africains. C'est-à-dire que ce sont les États africains qui vont encore subir, je dirais, ce sort des crimes contre l'humanité, comme cela a été fait pour la Cour pénale internationale. Donc, ils sont très réservés également sur ce point. Beaucoup ont évoqué encore une fois les principes de non-ingérence et d'égalité souveraine en ce qui concerne justement non-ingérence dans les affaires intérieures. Beaucoup d'États africains ont dénoncé également ce que j'appelle les politiques sélectives, c'est-à-dire des prétentions parfois hypocrites de certains États pour dire oui, il faut avoir cette convention, elle s'appliquera pour tout le monde, alors qu'en réalité, l'application risque d'être après sélective en fonction notamment de la loi du plus fort. Un autre point sur lequel je voulais également intervenir, c'est le fait que, je parle toujours de la position des États africains, on est pour cette explication jugée ou extradée, mais c'est une convention également qui adopte ce que j'appellerais une idée de la coopération internationale qui est très élargie, et également en ce qui concerne l'extradition. Là aussi, il y a des réserves de certains États africains pour revisiter cette question de l'extradition et faire en sorte que l'extradition ou la poursuite soit reprise sous un autre angle. Donc, ce que je voudrais dire au dernier moment, c'est que vous n'avez pas tort de dire que l'heure de la mobilisation a sonné. L'heure de la mobilisation a sonné à partir, bien sûr, déjà des positions acquises par certains États africains par rapport à ce projet de convention, mais surtout la mobilisation des organisations de la société civile. Et c'est important de dire que le travail doit se faire dès maintenant. Il n'est pas question de perdre du temps, les choses s'articulent très rapidement, mais dans la mobilisation des organisations de la société civile, je pointe du doigt tout d'abord l'expertise. C'est très important. La société civile qui doit s'exprimer, qui doit défendre ce projet, doit être une société civile avertie, suffisamment avertie sur ces questions. De notre côté, le plaidoyer qui va être développé est un plaidoyer qui doit s'inscrire justement à l'endroit de tous les États, de manière à essayer de capturer, encore une fois, les positions attentistes de certains États africains. Une question également importante dans le plaidoyer, c'est que ce plaidoyer doit également intégrer le rôle des institutions nationales des droits de l'homme. Il ne faut pas les écarter. Les institutions nationales des droits de l'homme sont un petit peu la courroie de transmission entre la société civile, les populations et les États. Donc, les INDH devraient également être sensibilisés à cette question. Et de notre côté, pour avoir un écho beaucoup plus grand, il ne faut pas oublier les centres de recherche, les cliniques juridiques, les universités, les facultés de droit, qui doivent également participer à ce débat en ce qui concerne la nécessité de doter la communauté internationale d'une convention concernant la prévention et la répression du crime contre l'humanité. Donc voilà un petit peu les propos que je voulais apporter par rapport à cette convention. Le commissaire Dersso va prendre la relève. Je suis sûre qu'il était déjà prévu sur le panel. Encore une fois, merci de m'avoir associé à cette discussion. Puis je pense qu'on aura l'occasion encore une fois d'entreprendre encore d'autres actions ensemble. Merci beaucoup.
Merci, Madame Fadel, pour vos contributions très constructives. Nous allons profiter de la présence du docteur Ayele Dersso, commissaire de la Commission africaine des droits de l'homme, pour lui donner la parole pour ses observations avant d'ouvrir la phase des questions. Monsieur le commissaire, vous avez la parole.
A very good afternoon to all of you. First of all, I would like to thank the conveners of this side event for the invitation extended to me to be part of this important conversation on the establishment of an international convention relating to the crime of against humanity. As the African Commission on Human and People's Rights, we in the Commission take particular interest in this discussion on the establishment of a convention with respect to the crime against humanity on account of the fact that historically, but also in contemporary situations, in various conflict settings in particular, the occurrence and perpetration of crimes against humanity is something that continues to be reported and documented, and in that sense, reinforcing the international system in terms of addressing crimes against humanity is of particular significance. Understandably, it's important to note that crimes against humanity do not necessarily presuppose or assume the existence of a conflict or war. It is possible that they could be perpetrated outside of a war or a conflict situation as well. And the importance, therefore, of this initiative for the establishment of a convention on crimes against humanity. It provides an opportunity for reinforcing the work of organizations like the African Commission on Human and People's Rights, who, on account of the nature of their mandate, couldn't deal directly with crimes against humanity, as we are principally a human rights body that deal with human rights violations. But when those human rights violations now reach a point or constitute crimes against humanity, they have to be dealt with through criminal investigation and other various forms of accountability mechanisms. It is on this account that we give particular attention to and support the initiative. And we do hope that African member states, states parties to the African Charter on Human and People's Rights, as part of the commitment that they have under the African Charter, including under Article 60 of the 60 and 61 of the Charter, that they extend support for the initiative towards the adoption of this international convention. Once again, I do hope that this engagement facilitates that process towards the adoption of the convention, and look forward to the promotion of the convention once it is adopted. Thank you very much again for the invitation and for this convening.
Merci, Monsieur le Président du groupe de travail sur les industries extractives, l'environnement et les violations des droits humains. Nous ouvrons la phase des questions précises, et parce que nous sommes derrière le temps par rapport à ce qui était prévu pour l'occupation de la salle. Des questions? Oui, monsieur au fond, oui. Non, devant.
Bonjour.
Bonjour.
Je m'appelle Frédéric Loa, je viens de la Guinée-Conakry. J'ai suivi avec intérêt les différentes interventions relatives à l'adoption de cette convention. Moi, j'ai une inquiétude, parce que quand je fais mienne tout à l'heure des inquiétudes de madame qui a parlé, quand on regarde un peu le fonctionnement de la Cour pénale internationale avec cette poursuite sélective, je me demande, est-ce quelle est l'opportunité d'adopter une telle convention? Est-ce qu'il ne faudrait pas peut-être renforcer les systèmes judiciaires des différents pays pour que chaque pays, n'est-ce pas, en son sein, puisse quand même prévoir, n'est-ce pas, cette infraction-là, et puis adopter des mesures allant dans le sens, n'est-ce pas, de sanctionner au plan interne. Parce que je crains qu'une telle convention, une fois adoptée, qu'elle soit seulement appliquée aux plus faibles, alors que les plus forts vont peut-être narguer et ne serviront jamais à appliquer cette convention. Je vous remercie.
Merci, Monsieur Frédéric. Deuxième. Oui, le monsieur au fond.
Good afternoon. My name is Michael Davis. I work for Public-Private Integrity. We are very much interested in this treaty, which is now being formulated. And we would like to raise the attention to the impact of corruption on humanity. We are seeing a lot of cases relating to corruption, and which is affecting a large group of people. We are seeing the case of the extractive industry, especially in the Congo, where a large population of people are being impacted because of corrupt practices. In the Gambia, we witnessed the Janet Commission, and it gave a lot of instances of corrupt practices, which is impacting on a large group of people. This can be considered as crime against humanity, because international law, I think it can be considered under the national law, and we should not leave corrupt practices unpunished under this treaty. This is the issue that I want to raise.
Merci. Oui. Au fond.
Yeah, thank you. I'm Samir Makin, this human rights lawyer. It is great to see the huge development for the human rights, and particularly crimes of humanity, that move it from the article in order to be a treaty. is something that I deeply appreciate it. But my question is going through the implementation mechanism. Yeah, what is the development of related to the implementation mechanism? Because yes, we have ICC as the mechanism, it is effective, but the issue of extradite is something that was lay on the willingness of the states. We have Omar Bashir was wanted by the ICC, and he was moving from state to state. Among them, there is the many countries are member state of ICC, and they did not extradite him to the ICC. And there was no effective action was taken against these countries. My question, which is new in this treaty about the implementation mechanism, particularly when the state rejected to extradite someone who is wanted by ICC or something like that. Thank you.
Merci. Deux dernières questions. Si on a, bien sûr.
Thank you very much. My name is Moya Nyaundi and I work with Open Society Foundations. To follow up on the questions on the first two gentlemen, especially given the hypocrisy, particularly of so-called democratic governments in terms of them. Let's say, for example, the U.S. is not a participant to the Rome Treaty. And it has been perceived that the ICC particularly has prosecuted mainly African countries. There's been a move towards strengthening our regional treaties. And I'll give an example with a move to get an appointment of an AU special rapporteur specific to the independence of the legal profession, because the UN special rapporteur, of course, is stretched thin. And hence it's better to have regional grown home treaties that we're able to build and push on our own. So African solutions for African problems, basically. So following up to the three gentlemen that have spoken ahead in terms of mechanism, the double standards, does it not make sense to have something that is homegrown that we can push and build? And hence why we're here in the African Commission session on its own. So yeah, that's, I'll end there.
Merci. Adam, la dernière question.
Merci. Bonjour à toutes et à tous. Moi, c'est Yémé Jainaba, je suis juriste de formation. Alors moi, ma question, c'est de savoir aujourd'hui, est-ce que dans cette convention, est-ce qu'il y a des mécanismes aujourd'hui qui nous permettront aujourd'hui, si jamais je prends l'exemple de l'Union européenne qui décide aujourd'hui de soutenir la Palestine pour l'Israël, pour tout ce qui va avec le conflit avec la Palestine. Et maintenant, nous, est-ce qu'il y a des mécanismes qui permettraient aux autres États aujourd'hui d'astreindre ces États-là ou bien d'amener ces États-là dans des tribunaux pour les juger contre les crimes contre l'humanité? Parce que pour moi, en fait, oui, c'est bien beau d'avoir la convention, mais est-ce que les autres États sont aussi forts pour pouvoir aujourd'hui dire à l'Union européenne, oui, ces actes-là, c'est des actes qu'on peut qualifier de crimes contre l'humanité et pouvoir penser à aller vers la justice? Pour moi, aujourd'hui, c'est important parce qu'on en a eu. La Cour pénale, c'est qui? C'est les Africains. Donc, pour moi, il faut réfléchir et c'est pourquoi je pose la question. Est-ce qu'il y a aujourd'hui des mécanismes qui nous permettront aujourd'hui, aussi bien l'Union européenne, aussi bien que l'Union africaine, mais aussi les États-Unis d'Amérique, de pouvoir vraiment les amener devant les tribunaux pour les juger contre crimes contre l'humanité? Merci.
Merci. Chers conférenciers, je pense que vous avez noté les questions, sauf si vous voulez que je puisse reprendre. Et si chacun pense intervenir sur un aspect, vous avez la parole, tout en vous rappelant qu'il nous reste peu de temps, je pense 15 minutes au trop pour libérer la salle. Merci bien.
Thank you, Madam Moderator. I want to respond to two questions, and perhaps my colleagues will also add on to that. The first is for my brother from Guinea Conakry on the apprehension that the universal jurisdiction regime proposed in the draft convention is more likely the experience that we have had to be applied to weaker states. Unfortunately, and this also relates to the question by Muya, unfortunately, the international justice system currently is dominated by double standards, where the same violations, the same kind of crimes under international law do not meet the same sanctions that is provided for under international law. So we unfortunately have to agree that the system as it currently exists, there is a double standard, there is a hypocrisy. However, we can also see that the experience of South Africa filing a case against Israel, the experience of Gambia filing a case against Myanmar at the International Court of Justice tells us that when a state is bold, when a state is willing, it is possible to tackle the big powers. That we might be weak in economic terms, in geographical terms, but our courage can be mighty in at least sending the message to the big powers that the international justice system that we want is an equitable justice system, that every perpetrator, regardless of their nationality, should be held to account. And I think the experience that we saw from South Africa, the experience that we've seen from Gambia, tells us that it is possible to use universal jurisdiction. It's possible to use the international law system to hold accountable even the bigger powers, and in this case, for instance, Israel. On the possibility of homegrown mechanisms, I think this is a valid point. However, one of the utilities of a global draft convention on crimes against humanity is the possibility of not creating a safe haven anywhere. So that if you commit a crime in Sudan, in South Sudan, in Kenya, in Sierra Leone, wherever you are, you cannot be able to run to another country outside of the continent that has ratified at that time this particular convention, or that has committed to this particular. So the utility of a global nature of the treaty is that it will enable us to have no safe havens where perpetrators can run to. But even at a secondary level, we have seen movements on the continent to try and establish continental mechanisms for holding perpetrators of crimes under international law to account. And in 2014, the Malabo Protocol that extends the jurisdiction of the African Court of Justice and Human Rights to include criminal law was adopted. Since then, it's almost 10 years, only one country has ratified that treaty, Angola, which they did actually this year. But more importantly, and unfortunately, this is what then undermines our own efforts to hold perpetrators in Africa accountable, is that the Malabo Protocol has quite problematic provisions and clauses, for instance. And one of these is Article 14 that provides for immunity of heads of state and senior government officials who cannot be prosecuted or investigated under the Malabo Protocol. And yet we know in reality, they're usually the masterminds, the planners, the financiers of crimes under international law. So yes, a good idea for us to consider homegrown mechanisms, but one, we must consider the utility of global mechanisms, and two, the challenges that we also face continentally in developing our own mechanisms. Thank you.
Thanks. I think Japhet's response has really will help me in just taking it a bit further. And what I hear from the questions that came from the floor is concerns about selectivity. Our friend Frederic was mentioning that. And of course, the concerns around the hypocrisy and the double standards, which have also come through. But I want to stress the one point that Maya Sahli Fadel mentioned before she left, which is that we are dealing with state responsibility here. So we need to separate the individual criminal responsibility that comes from, for example, the Rome Statute, Article 7, that is very clear on crimes against humanity. And here we're talking about a treaty where we will be discussing the prevention and punishment of the crime against humanity. And there the distinction is that the selectivity, the double standards, and all those other processes that you've mentioned are indeed alive, they're active. But I think what particularly South Africa versus Israel at the International Court of Justice has done for us is to see that it is possible to actually call the powers that are mighty in this world to account for what they're doing. And that's really what this process should, or we need to take out from this process. So there's the international criminal component, which is individual, but that's not what we're talking about. We're talking about states that have a responsibility to prevent and to punish the crimes against humanity. I want to invite us to look at all these mechanisms as complementary and not in competition with each other. So I agree that it is important to have sub-regional or regional treaties that would take care of these crimes. That's actually very welcome. If the African Union decided that they want to actually have a specific treaty that looks at state responsibility for crimes against humanity, they should. It's not a competition. There's a gap in international law right now that we do not have a treaty where we could call states to account, or where one state can say, on the basis of this right in international, this is a peremptory norm, just as the Gambia did for Myanmar, just as South Africa did for the people of Palestine, to say that not under our watch will we wait to, we will see that these countries will continue perpetrating these serious crimes against civilians. So this is what this process is about. And just to be clear again, we are not yet there in terms of what the nuts and bolts of the treaty would be like. For now, our step is, let's write to our governments, as civil society, as national human rights institutions. Let's tell them that support this process at the 6th committee level. In 2026, when we get the opportunity to start negotiating the treaty itself, then we can get into the details of the definitions, the gender persecution, the gender apartheid, all those things, and also the enforcement mechanism. So this is where I'm going to end, the issue around enforcement. And I know right now we're struggling with trying to get Israel to comply with the provisional measures that the International Court of Justice has issued. That's the question that we should really be focusing on. It's not for now, it is for the treaty negotiation stage. But remember, I talked about the complementary nature of international law. So you have the International Court of Justice making a decision saying, this is what Israel must do. We have an enforcement mechanism with the Security Council, but because of the dynamics of the Security Council, then it might be difficult to actually get Israel to comply with a decision from the security. Well, that discussion will not even make it to that platform. So what can we do in the negotiation process to protect those sorts of allegiances that might actually undermine the decision of the International Court of Justice? It's open. It is a carte blanche. States would have to think about it based on the experiences that they have. Right now, we're struggling to get Israel to comply. The United Nations Security Council, which is supposed to be the enforcement mechanism of the International Court of Justice decisions, is paralyzed. So how will we move that forward for the Crimes Against Humanity Treaty? That is still out there to be discussed. But we need to get to that point first, where the UN 6th Committee says, let us go into treaty negotiating process in order to then handle these issues. Thanks.
Thanks. I won't have much to add because my colleagues have given very informative answers, but I just wanted to make a point about this question of enforcement. And I think we see the reality as that international law is ultimately what we make of it. And that we have seen, especially in Africa, the work of activists and campaigns help realize the aspirations of international law and the obligations that states agree to. So obviously in an ideal world, as soon as those obligations are committed to, they would be implemented. But it is possible, and we do see over time that positive change can happen using those frameworks. And I think of tremendous progress, for example, in the recently concluded trial of the September 28th massacre in Guinea. That was not anticipated early on. We have seen accountability from the Habre trial. We have seen Charles Taylor's trial. Progress can happen with respect to accountability. And the more tools that can be agreed to are important aspects that can be leveraged by activists and governments that care about these issues. In terms of selectivity, I just want to add as well that the reality is that this treaty focuses on individual obligations of states and is really about states creating systems where crimes against humanity can be prosecuted in their countries. And so that is an opportunity then to push for domestic cases, which of course, if that is done, negates some of these questions around selectivity, although they certainly exist in the international space. I want to also add two logistical points or administrative points. One is that for those who want more information, I want to give the address of the micro website that is fully devoted to the Crimes Against Humanity Treaty. It is, for those who wish to write it down, CAH, Crimes Against Humanity, CAHtreatynow.org. That's CAHtreatynow.org. That's where you can find information about the effort and also resources in case you want to publish something or write to your governments. I think all of us, as Allan said, stand ready to support and assist efforts to encourage more states to take part. So please do not hesitate to come and speak with us after. There's also a sheet going around where you can put your information, should you like to be added to receiving information about this effort going forward.
Merci.
Merci. Moi, je voulais compléter un peu par rapport aux réponses pour dire que le caractère subsidiaire de la justice internationale voudrait effectivement que l'on renforce le système au niveau national pour qu'au niveau national, le travail puisse se faire. Mais on sait que parfois, la volonté politique fait défaut. Et si je prends même l'exemple de la Guinée, hein, franchement, le procès du 28 septembre, c'est à la fois une combinaison de pression de la CPI et des enquêtes du procureur et qui a déclenché et qui a favorisé effectivement cette volonté politique de l'État guinéen à mettre en place un tribunal au niveau national. Donc, pour vous dire, c'est une complémentarité de ces systèmes qui peut aider à lutter contre l'impunité. Et que la lutte contre l'impunité, c'est un processus qui prend du temps. Il y a très peu de temps, il y a moins de 20 ans, qui nous aurait dit qu'il y a des grands dictateurs dans ce continent qu'on pourrait poursuivre à travers des tribunaux, à travers des procès. On n'allait pas le croire. Aujourd'hui, on a vu le procès de Hussein Habré, les chambres africaines extraordinaires à Dakar. On a pu le faire aussi. On est en train de vouloir le faire pour d'autres. Et je sais que c'est maintenant possible. Demain, ce sera également possible de ne pas se limiter seulement à condamner l'Israël d'auteurs de crimes contre l'humanité, mais de disposer de moyens de rendre l'État d'Israël responsable, effectivement, et d'un mécanisme pour pouvoir juger. Je pense que c'est comme ça, petit à petit, qu'on peut aller vers la lutte contre l'impunité. Et terminer par dire que la prévention, aujourd'hui on est en Afrique, Adama Dieng a été élu récemment nominé comme responsable de l'Union africaine pour lutter à la prévention du génocide. Dans ce cadre, effectivement, ce genre de mécanismes aussi peuvent exercer une pression sur les États en vue de ne pas en arriver à un génocide. C'est-à-dire, dans le cadre de la prévention, ça peut être une bonne chose pour prévenir d'autres crimes, comme les crimes de génocide et les crimes de guerre. Voilà ce que je voulais dire.
S'il n'y a plus d'autres interventions, nous allons remercier Monsieur le commissaire pour avoir disposé du temps et nous avoir rejoints sur ce panel. Nous remercions Monsieur le procureur général pour sa disponibilité aussi. Madame Simiti, commissaire à la Commission des droits de l'homme de la Sierra Leone, chers panélistes, chers participants, merci beaucoup pour vos contributions et votre temps. Merci. Ils n'ont pas présenté de communication, donc je vais essayer, mais il n'y en avait pas prévu. Le tableau qui est là, c'est comme ça que ça apparaît. Ça, c'est les discussions avec tout un chacun qui a permis de préciser les points. Vous êtes appelé pour une photo? Ah, d'accord.